Hello and kia ora. My name's Nuncio D'Angelo and I'm a Vice President and Board Member of the Banking and Financial Services Law Association. As you'd have noted from the advertising material for this webinar, Professor Joshua Getzler is a Professor of Law and Legal History at the University of Oxford and maintains an ongoing connection to Australia as a Conjoint Professor at the University of New South Wales Law School. That brief description barely even begins to scratch the surface of the impact Professor Getzler has had and continues to have on law and commerce internationally in a number of areas, including duties of investment agents in financial markets, the legal and economic structure of debt and equity securities, the liability and ontology of juridical entities, and the theories of trust, fiduciary duty, and co-ownership. In his historical research, he's currently working on the nature of fiduciary accountability in private and public relationships, including crown liabilities and public finance, very topical, and the evolution of property, trust, corporate, and charitable forms. He's presently engaged in advisory work for governmental and native parties dealing with the interrelationship of native title, trust, and fiduciary accountability in relation to First Nations, with special reference to British North America, Upper Canada, and New Zealand, also very topical in Australia. On a personal note, I was honoured to have Professor Getzler be one of my PhD examiners many years ago. His gentle but firm feedback reminded me that no matter how clever I thought I was, giants walk among us. I could go on. No, seriously, I could go on. His list of publications, appointments, and achievements is astonishing. But I suppose I should leave him some time to actually present his paper. With that, I'm honoured and delighted on behalf of the BFSLA to welcome Professor Getzler to speak to us about a topic that begins with the humble and ubiquitous bank account, a deceptively simple creature with a fascinating past and, with the evolution of modern banking and cryptocurrency, perhaps an even more fascinating future. Professor Getzler, over to you.
Well, thank you, Nuncio. That's the warmest introduction I have ever had. I just hope I don't disappoint you after this wonderful encomium. I learned a lot from your PhD, and we debated still in Oxford. You really did make a pioneering effort in looking at the commercial trust. So wonderful to be in contact with you again after the long, hard years of COVID. I'm very grateful to be here to speak to the BFSLA and to my colleagues from Bar and University here in Auckland. I'm grateful to Alison at UNSW, Laura, Julia, James, Nuncio at BFSLA, Nicole and Peter here in Auckland for helping me engage with the law in this wonderful jurisdiction. I'm also grateful to Credit Suisse and Silicon Valley Bank for making my topic even more pressing than I thought it was. And I think I might just start with an indication of why my schizophrenic character as a legal historian and a legal economist and a common lawyer, what I think I'm up to. I think the answer is we all sit in law school, or we sit in practice, and we come across a really important case that we're told is foundational, is a benchmark case, what Brian Simpson would call a leading case. And we accept it as authoritative, but you might have some mental itch. What does it mean to be a neighbor? What does it mean to say that a fiduciary duty can only be negative? What does it mean to say that a bank deposit is only a debt relationship? And we read these great cases that found whole chapters of the law. And sometimes I think I don't really understand why that is so. Is it arbitrary? Can it be explicated? And sometimes it can take 10, 20, 30 years until you find the tools to crack it open and see inside the problem. You may not get the answer, but you may have better questions. And if I give away the punchline straight away, we should tell law stories, unlike Agatha Christie, we should solve the whodunit at the start. I think that the simple question, what is a bank deposit, is of enormous importance in understanding commercial and financial law and markets. And I'm not the first person to have noticed this. The Austrian economist Ludwig von Mises, father of a great school of austere libertarian finance theory, in his 1912 book on interest and credit, noticed this law in the common law. And he itched against the idea that the bank deposit was a simple debt. And I'm going to try to explain why economists of his stature noticed the delicate issues inside the doctrine of bank deposit law, and what we can tease out from this, the historical lessons. So what I'm going to do is, there is a circular, a list of authorities. I'm not going to speak my way through that as a kind of a reading guide. Instead, I propose to actually read you the paper, which is full of a lot of common law discourse from very great judges, and to try to show how the judges themselves in constructing this doctrine are quite hesitant in a kind of a lengthy seminar to try to understand what is money and what happens when money is put at bank. One more introductory comment. There's a big debate raging amongst the Oxford and Cambridge and London and Sydney and Melbourne lawyers and Auckland lawyers. What is the inheritance of Peter Birks's restitution theory? And I was talking about this with Professor Peter Watts. And one thing that bothered me in learning unjust enrichment is, what is an enrichment? So much of it is about a mistaken payment. What is a payment? What is a payment? And do we really even understand the distinction between a bill, a check, an assignment? What does it mean to hand over money? And until we really work out, David Fox has asked these questions, what are the raw materials? What is the DNA of our practice? Then we might not be getting other issues right. So let's begin. In the leading House of Lords decision of Foley and Hill, decided in 1848 in the House of Lords, it was ruled that if a banker had failed to account for a customer's bank balance, including a failure to acknowledge or pay over the agreed interest for a period longer than 6 years, then the extant limitation statute, which is the old Jacobean statute from 1624, 6-year limitation period on debt, was effective to bar the customer's claim to an account of the balance. Hence, if you leave your money in a bank in 1848 for 6 years without going to the bank keeps the money. That's the ratio of the case. It's quite surprising. The idea that if you just forget to go to the bank, or you have no business to go to the bank and leave your money there, after 6 years, you can't claim the money anymore. That's the decision. And you also forego the accrued interest. As part of the reasoning, the Lords affirmed Lord Lyndhurst's view that a customer depositing money in a bank account can only have a conventional debt claim against the banker and cannot normally demand an account in equity to measure a fluctuating balance. That is the accounting procedure to require the fiduciary to report where the assets are and what the state of the assets are, the informational element of accounting. Nor can you use an equitable procedure to maintain the banker's duties, to require the banker to show what he or she is doing with the asset, and to surcharge or falsify the account to bring it to its proper balance. Now, some 5 separate courts of equity heard this cause across a 10-year span of litigation. And of all of these courts and all of these judges, only the first instance judge, Vice Chancellor Knight Bruce, thought that a Chancery Court had the power to enforce the return of bank money. He found a continuous equitable duty of account that bound the banker throughout the lifetime of the deposit that was effective to circumvent the limitation period. But according to all of the other judges in the appeals, this claim embodied in a positive bank balance was still a simple debt only and subject to normal limitation rules. It was a peculiar debt though, because a bank deposit has no normal terminus or maturity date. You can have a bank deposit where after so many months or years, the bank says you have to take the money out, we're going to change the interest rate. Or you could have a bank deposit that says you can't take the money out unless you give notice. You can play around with the contractual terms of deposit. But the plain vanilla bank deposit involves a deposit where there is no term for the return of the debt. But there is a right to demand the money if you go to the bank and demand payment. And that seems to be the essence of the bank deposit. So already to call it a simple debt doesn't quite work because we have this payment on demand overlay onto the debt. It is also normal to be able to require a report of the balance, normal for the bank to offer a facility for drawing payment orders on the bank for the benefit of third-party payees, such as personal or negotiable checks, which give the payee an autonomous claim to payment from the depositor, raised at the bank and payable upon acceptance. And overlaying that implied term, there might further be an overdraft facility annexed to the deposit account. And in this period, mid-19th century, overdraft facilities were terribly important because this is what provided a lot of the circulating credit for cycles of industrial and commercial trade. And the judges in Foley and Hill recognize that all of these super added customary and contractual rights are part of the banker-depositor relationship. But they held that all of these add-ons are defeasible augmentations and do not transform the basic banking relationship into anything like a bailment or a trusteeship or a deposit of the money at bank. And when we say deposit, that's purely colloquial. There is no deposit of particular money in a vault, nor is there deposit of money into a mass where you have some kind of charge Goldcorp style over a shifting mass. Only if the bank accepts to take on a role as a manager or bailee of money in a box which has been segregated, or some kind of body of assets which is subject to a charge, could anything like a fiduciary duty emerge. And the reason why the lawyers, in the face of some doubt, insisted on the pure debt basis of the bank deposit was so that the bank should have full title to the money and power to direct its use value. The bank has to be able to treat the money as its own, so it can lend the money out to its debtors, the people it finances, and they can treat the money as their own. Or alternatively, the bank may have its own proprietary capital, which it invests in the bank's own name in external security instruments, typically Bank of England bonds, so that the bank has got a layer of capital to sustain its operations. If the bank did not have the full title to the money deposited, it would not be able to do these operations. By excluding the doctrines of property, agency, trust, bailment, and fiduciary law from the pure contractual streams of banking law, Foley and Hill was received with acclamation by the banking profession as a welcome clarification and simplification of the law. It provided a foundation for modern fractional reserve banking, allowing credit expansion and financial intermediation in the mid-Victorian economy. And we could argue that Foley and Hill is to banking as Salomon is to company law, as Donoghue and Stevenson is to tort law. However, not all commentators have been so sanguine about the consequences of the decision. Economists of a libertarian bent, notably the Austrian school beginning with Ludwig von Mises in the turn of the century, have seen the stream of case law as undermining an alternative tradition of banking based on depositum irregulare. This is the idea that a bank should be able to match its obligations with 100% level of circulating security. Any placed deposit must be warehoused within a fungible mass by a deposit accepting bank, giving the depositor a complete commercial and legal security. This confines a bank taking deposits from normal people on the street to cashier and payment services rather than lucrative and risky intermediation and maturity transformations. In the Austrian economist's world, we must match the ability to bear risk to the nature of the depositor. And if you're going to give money to the bank to manufacture credit and to leverage finance, then the depositor has to be some kind of co-partner or investor who is bearing that risk. Now, this seems very, very interesting because we've just had a big banking crisis 12, 13 years ago in England and America. And the crisis involved, to a great degree, simple people putting their deposits into Northern Rock. The bankers then generating extravagant credit relations on the back of that body of deposit. And then when the credit mountain fell down, asking for government bailouts because otherwise vulnerable depositors who didn't understand the risks would lose their money. And this is a recurrent story in the history of banking. What happens if you have not just a systemically important bank, but a bank of a lot of vulnerable depositors, or a building society? Sinclair and Broome comes to mind, where the punters, if you tell them you should have checked the bank's credit before you put your money with them, that might not work in the real world. That depositors, we can't say caveat emptor, watch out what type of bankers you use. Now, these debates are now swirling around Silicon Valley Bank, because the investors in Silicon Valley Bank were grown-ups taking risk in an entrepreneurial market. So there's a big debate in America now. Should the US government bail out such a bank when the depositors are not vulnerable? So do we have to distinguish between different types of bank? This is already talking the language of Austrian economics. There's another problem which is not policy-oriented, but about legal logic. What does it mean to say a banker can own client money outright, but must be expected to repay a like value on demand? If I say, can I borrow a cup of sugar? well, that's a mutual. Am I going to consume the sugar? I'm not going to give it back, but I'm going to give the sugar back in like form. I'm under a kind of obligation. The moment I baked the cake and done my children's birthday party, I get to the shop as fast as I can to buy sugar. So when my friend comes to get the sugar back, I have a stock. So if we tighten up that idea that you have to have a fungible mass to back up your obligations, we're going to start to put pressure on bankers to have a layer of regulatory capital, not because a politician told them to, but because it's the structure of the law that to balance out your debt obligation with your ability to give instant repayment on demand, the doctrine is going to force you to have regulatory capital. And I didn't think of that by myself. David Fox read the first version of the paper and told me that's the implications of what's going on here, major theorist of money. Okay, now a couple of other points before we plunge into the case law. The judges in Foley and Hill thought they were deciding a narrow range of legal questions concerning legal defenses. Only one of the judges, the Lord Chancellor, said, we're doing this in order to root our banking practice. The other judges thought this was all about limitation periods. It is later courts and commentators who have read into the decision the much larger legal policies that they would have liked to exist and therefore attached to the case. Secondly, there was a continuing legal to and fro and uncertainty remaining in the law about the nature of the bank deposit. And this perhaps reflects a deeper fragility and instability within the growing banking sector of Victorian Britain. And there were many solutions to this problem, the mismatch between the payment on demand duty and the ability to treat the money as your own to generate credit. And let's just quickly go over some of the devices. The earliest device was that the banking directors were partners with full solidarity liability, and if they crashed the bank, they would be personally bankrupted. And having small banks, sometimes known as country banks, known to the local community, you kind of knew who your bankers were. It was like the country doctor. And this intimacy of knowledge, personalized banking, was the original way in which we could control risk-taking by our bankers. There were also interbank lending pacts. If one bank got into trouble and there was a run, and another bank in a different region of a slightly different economic cycle had liquidity, you would load bullion up into a stagecoach and rush it across the country to stop the run on a bank. And we still have a lot of interbank lending. CEG, Credit Suisse is taken over by USB. There's been a lot of interbank lending to support Silicon Valley Bank in America. We saw that on a grand scale in the financial crisis in 2008. We have government deposit insurance. We have, following John Vickers' report, the ring fencing of savings banks and commercial banking operations. We split banks up between the risky and the non-risky parts. We have macroprudential banking regulation requiring capital buffers ordained by government, and ultimately the threat or promise of government nationalization. All of these vast ramparts of political economy and regulation are driven by Foley and Hill. You need to find ways, if you're not holding 100% depositum irregulare, a circulating fund to back your obligations, you need to do all of this other stuff to keep the banking system alive. And now we know why von Mies hates Foley and Hill, because his argument is that once you have to build up this huge government regulation with the backing of government nationalization to control the banking system, we've given up our freedom to government. The government can choose winners and losers in the financial system. So von Mies is arguing that by taming the financial sector through requiring this rigid division between savings and commercial banking, we may have a smaller financial sector, we may be poorer, but we will be freer of government control. Now, as someone very much on the left, I was surprised to find how I found good echoes in a libertarian right-wing economist's theories. And that gives some hope that this isn't just a political shouting match, that we can see in different political traditions ideas that might be helpful to us in navigation. Another very interesting modern theorist is Katerina Pistor, who published a splendid book in 2019 called The Code of Capital. And she argues that lawyers are key in the construction of capital, that very able litigation lawyers will help their clients to shape risk and shift risk away from their clients towards other entrepreneurs, consumers, governments. And that we must study the intricate detail of financial law to see how this works. And she argues prescriptively for stronger public order, which disciplines the experimentation of the lawyers and restrains their pursuit of profit for their clients. Her theory can neatly be applied to Foley and Hill as a decision where the judges privileged the banker and the banker's profits and held against a depositor who was a rather inert aristocrat storing his money. And in the fight between these two forms of capital, the legal system very much chose active financial capital. So it kind of fits Pistor's model. One of the very important books of the early 20th century on banking in America was written by a certain Louis Dembitz Brandeis, who went on to the Supreme Court. His famous book, Other People's Money and How the Bankers Use It, published in 1914, he made the argument that the able lawyers defending bankers' interests were actually undermining industrial capitalism in America. And he saw very much his role on the Supreme Court as trying to reverse some of the drift in financial law towards shifting risk away from bankers. Okay, well, that's a kind of a fun political economy introduction to the case. Now I'm going to go back a little bit way in time and try to show the precedents that lead to Foley and Hill and show how the lawyers are very sophisticated in handling these problems. So I've given you the references to the Foley and Hill judgment. If you want to see some of the other cases, I start under the heading Legal Development of Banking Concepts. And I'm going to be talking my way through some of these cases. Now, we have a saying in Yiddish, the shoemaker likes leather. I'm a common lawyer who reads cases. I like cases. So I'm going to invite you in to join me now to study a few cases in depth. So very much a change of gear. Lord Mansfield, the great 18th century judge, offered a definitive treatment of the legal nature of money and currency in Miller and Race, decided in 1757. And I suspect he was influenced by the theories of his intellectual companion and compatriot, Adam Smith. In this case, a banknote was stolen and was then delivered to an innocent third party in return for consideration. The innocent third party presented the banknote, and he sued the bank when the bank refused to honor the note. This raised the deeper question of the legal nature of a banknote and the relation of title to the paper and to its embodied money value. Lord Mansfield explained that banknotes were paper money and the title passed on delivery. And to reach this point, he had to dig a bit deeper and explain money itself. And I put the quote up here. I'll read it through if you will allow me. Money, properly speaking, is whatever common consent has fixed upon as a sign denoting a certain value. And though commonly of gold or silver, yet sometimes of mixed metals, and leather stamped has been used, so may paper, seeing whatever the material is, common consent may make it money to all intents and purposes. And that banknotes are so received and not considered as documents of a debt or securities for money only, appears from many determinations. The use of current specie is that where it passes from one to another for good consideration and without collusion, it can never be traced or demanded by any former possessor, which has given rise to a quaint expression that money has no earmark and therefore cannot be followed. Earmark is when you put cows onto a common, you can take the same number of cows out. You don't have to worry which cows unless you put an earmark on. So it's the idea of fungibility. Now, this is not true for money when it can be distinguished as some particular pieces may, or in a purse, may be followed as far as a banknote may. Now, it's quite a rich quote. It's seen as the foundation of monetary theory in the common law. And it'd be quite interesting to drop the word crypto or blockchain into this list and see if it can still work. And what's interesting here is it's a consensual theory of money. There's no state here. There's no state fiat or state blessing of the money. Banknotes are here produced by private banks. And libertarian entrepreneurs like Peter Thiel in America, who was a big loser in Silicon Valley Bank actually, has argued that we really want to move to crypto money generated privately without regulation to free ourselves of the state. Back to Miller and Race. In that case, the note had not been segregated when it was placed with the bank, but presented in the ordinary course of exchange, seeking it to be replaced with another money form, coin. And the plaintiff could insist on the value of his paper money and recover by a sumsit for money hadn't received, a sum equivalent to the note value, or alternatively seek a remedy in trover from the defendant bank who had received the note. This was not a deposit, but an exchange of one form of money for another. Now, the next case is the 1811 case of Carr against Carr. And here we have to introduce another feature of common law of money, which I think has been hidden from view, which is how to interpret wills. How to interpret wills. And in the 19th century, we began to develop what's sometimes called the armchair rule, which is because a testator has written down on a scrap of paper their will under the Wills Act, stating where they want their wealth to go, they may not have had a lawyer or a good lawyer to advise them. They may have had their own private language. They may call their nephew their son. They may call their son their nephew. There may be a lot of local knowledge. And the question is, what kind of objective, subjective mix of terminology do we use to interpret the language of a testator who is gone and we can't ask them what they meant? And the judges develop an armchair rule that we try to look at wills from the position of the armchair of the person writing the will. What if they write in their will money, cash, money at bank, deposits? The lawyers have to have some theory of how to interpret bequests, legacies, when there are rival factions in the family and rival creditors all trying to get at the corpus of the deceased estate. In Carr and Carr, a testator bequeathed to the plaintiff, quote, whatever debts might be due to me from the plaintiff or others at the time of my death. This clause seems to have been intended as a forgiveness of a debt owed by the plaintiff to the testator, which was effected for the drawing of a bill of exchange by the plaintiff in the testator's favor, which had been lodged with his bank, but which had not yet become payable. In other words, the testator is giving a debt vested in some third party to the debtor as a fancy way to cancel the debt. The testator, in addition, was owed debts by other parties and had a cash balance at a bank. The residue of his personal estate was granted to the defendant. There was no question that all third-party debt went to the plaintiff under the will. The question before the court, with the great Chancery Judge Sir William Grant, Master of the Rolls, sitting, was, quote, whether this bill of exchange in the said cash balance, or either of them, passed to the plaintiff by the above bequest. If money in the hands of the bank could be described as ready money at the testator's demand and disposal, then the defendant claimed that the money value was a residue rather than a debt. Sir Samuel Romilly, for the plaintiff, contended that the bill and the balance were choses in action. They could only be recovered by a court action and therefore must be considered as debts. King's Counsel Hart, for the defendant, submitted that the bill of exchange was delivered to the bankers by the testator as money, as if in his own possession. The money is held in the hands of the bank on behalf of the testator. The cash balance could not be considered as a debt in the contemplation of the testator. Though strictly speaking a debt, yet it was, in the common opinion of mankind, considered as money deposited with the banker. And in the construction of wills, words ought not to be taken according to their strict legal meaning, but according to the intention of the testator. And in this case, the testator could not have conceived the money at bank to be a debt. Romilly hit back, rejoining that a deposit claim against a bank was clearly nothing but a debt, as it might be proved under a commission of bankrupt. It would not pass under a bequest of all the testator's ready money, and therefore must clearly pass as a debt. Now, Grant found for the plaintiff on all counts. That is, the money at bank was a debt. It was clear that the bill of exchange, like the third-party claims, passed as a debt, being a chose in action. It did not matter that the plaintiff himself had armed the bank with the power to draw the funds as a debt claimed for the testator. The bank balance, however, gave the judge more problems than the bill of exchange. And this is the report of Grant's ratio. Grant entertained some doubt on the other point, but thought that the money which had been paid into the bankers ought also to pass as a debt. This was not a depositum. A sealed bag of money might be a depositum, but money paid in generally to a banker could not be so considered. Money has no earmark. When money is paid to a banker's, he always opens a debtor and creditor account of the payor. The banker employs the money himself and is liable merely to answer the drafts of his customer to that amount. It would not pass as ready money and therefore must be considered as debt. Now, some have seen in this judgment that Grant is assuming the custom and expectation of fractional reserve banking. All the parties are expecting that the banker is treating the money as his own. Just lost my draft on my tablet, so let me get that back again. Perils of technology. Okay, I'm back. But what Grant did not address is the problem of the money being freely available on demand. And this is what's discussed next in the law. We now come to a celebrated and very difficult case, Devaine's case of 1816, Devaine's and Noble. And this case has within it a sub-report, because law reporting is quite messy in this earlier period, of Clayton's case, which is a foundation case in the world of tracing. And I'm going to acknowledge my own debts here. My colleague Andrews Televantos, in his doctorate and splendid book, is the guy who worked out what this case really meant. And my account is very indebted, excuse the pun, to Professor Televantos. This is a Grant and Eldon case dealing with the problems of an insolvency of a partnership bank. The banking firm of Devaine's failed in 1810. Devaine's was a founding partner of the bank who died in 1809. And his son Devaine's took over his estate, including the right to the partnership profits, but he did not join the partnership, and he took out the inherited partnership capital some 9 months later and asked that his deceased father's august and respected name be removed from the trading name of the continuing banking business. After Devaine's had died, his partners had continued to use his name because it reassured the customers that his creditworthiness was still somehow present after his death. The customers continued to trade with the renamed and reorganized firm, but the bank failed within a few months, and its surviving partners were bankrupted and liable to the creditors of the bank. Some creditors sued the son Devaine's for bank debts amassed by the partnership at the time of his father's death, claiming that the depositors owed money by the partnership bank should have satisfaction against the deceased estate for the partner's share of firm debt that was run up whilst the father was a member of the firm. And the counter argument was that when one of the partners had died, a fresh partnership had formed, and if the creditors wanted to get their money back from the firm at that point, they should have asked for the money in the dissolution of the initial partnership, rather than expected that the fresh partnership would cover all the debts of the prior partnership. And there's a lot of very difficult law in the 18th and 19th century about how changing partnerships of different members owe debts to changing groups of creditors. Lord Eldon upheld the basic principle that a partner, having left a firm, remains liable for partnership debts contracted while still a partner, unless that debt has been formally released by the creditors and adopted by the remaining partners. Devaine's, the son, then appealed the master's findings. In Sleech's case in 1816, part of the same litigation, Hart, the same counsel as we saw in Carr, argued for Devaine's that since Sleech as a creditor had already been paid a dividend from the failed bank by the surviving partners and had settled and composed her claims against those partners, this creditor was shut off from suing the departed partner's estate for debts. And the argument is that the bank is a kind of a group or entity that has a separate existence from its living partners. So by dealing with the existing partners in the second partnership, the creditor had acknowledged that any obligations of the past partners were released. Now, in the interest of time, I'm going to simplify. The argument was run that by failing to sue immediately on the death of the partner, Sleech was now subject to the equitable doctrine of laches and had surrendered her claim against the departing partners. Now, Sir William Grant agreed with the bankers, with Devane's, and held that it could not be argued that Sleech had given up Devane's debt when she failed to sue his estate on his death, nor could she be said to have composed her debt by dealing with the other partners. He applied Lord Eldon's ruling that the individual partnership liability survived departures from or dissolution of the partnership. The bank was not to be taken as an entity holding debt only against its present membership, even if many traders customarily treated it as such. Normal mercantile practice could not change the basic principles of property and obligation. To accept the defense case, the customers must sue for their deposits for the value in the bank instantly on the death of a bank partner or face a laches defense would only encourage depositors to make a run on the bank and recover their money every time a bank partnership changes membership. This would be intolerable and would disrupt the production of credit. So it was better to state that a departing bank partner was fixed with the normal debt liabilities of a partner leaving a partnership. So it's not really dealing with the problem of what is a bank deposit as such. It's dealing with the problem of how we dissolve partnerships and how we apply a jingle rule to distinguish between the inside and outside debts of a partner. But along the way, Sir William Grant took time to examine and reject the bailment deposit hypothesis that was made in Devane's defense. Now, it's quite a long quote here, which I won't read to you in the interest of time, but he carefully goes into the problem of deposit, and he says money paid to a banker becomes immediately a part of his general assets. He is merely a debtor for the amount. When a man lodges money with a partnership of bankers, he is as much concerned to look to the solvency of each particular partner as if he was lending the money to any other partnership. The money ceases to be his the moment he has parted with it, and he must trust in the solvency of the persons into whose hands it passes. And he goes on to develop this theory. Now, it's very important because we've got one of the great judges of the early 19th century who explains that it is the personal creditworthiness, the personal probity of partners in small banking practices, which is the ultimate guarantee of bankers' deposits. And we have to remember that in this particular stage of financial development, this very personalized banking is the undergirding of the doctrine. This is why it's such an important judgment. So we have two major statements by Sir William Grant in 1811, 1816, establishing the debt concept of deposit based on the personal credit of partners. Now we have a string of judgments which I've listed here at the bottom of the page here, where the wills cases come back to haunt the courts. And I'm not going to be able to go into the details of each one, but I want to give you a very quick conspectus to give you a flavor of what happens next. We'll start with the case of Vasey and Reynolds, 1828. A testator made a will giving to my wife all and every of my book debts, monies in hand, stock in trade, etc. He next gave to named executors all and every my monies out at interest on mortgage, notes of hand, and any other security whatsoever, together with all my monies vested in the public funds. The issue before court was whether a bank balance fell into the money in hand class of immediately available money, or else whether a bank deposit was a shows in action that had to be realized via a prestation, security, or sale. The banker in this case had no overt duty to pay interest, and the balances were payable on demand. The banker customarily paid 3% on the balances left for more than 9 months. So John Leach, Master of Rolls, found as follows. The testator has referred to two descriptions of monies in hand and monies out at interest on mortgage, notes of hand, and other securities whatsoever. The balance in the banker's hands though it carried interest, was not out at interest on security, and it was in the same order and disposition of the testator as if it had been deposited in his own drawer. It must be inferred that the testator meant to pass by one of the two descriptions which he had used. In no sense was it money on security. It was money in hand and passed therefore to the wife. Now, to unpack this, the fact that you can demand the money from your banker is as if the bank keeps your money in a drawer. He's holding it for you. Therefore, cash in hand goes to those parts of the will, those heirs who are given cash in hand. It seems to cut right across all that went before. A decade later in Taylor and Taylor, Lord Langdale summed up this stream of authority as follows. It is true that in strict legal language, what is called money deposited at a banker's is nothing more than a debt and cannot be called ready money. But in the ordinary language of mankind, money at a banker's is called ready money, and we must construe a will according to the ordinary language of mankind. This is the armchair rule in big lines. We have cases that follow 1830 Marzetti. The duty of a banker to honor checks drawn for third parties was held to be an express contract, quite independent of the nature of the balance as a debt. By building into a bank balance an expectation of instant payment to the depositor or to his or her payee, the court recognized a legal quality of control or order of disposition, using insolvency language, over bank deposits, which they compared to possession. You possess the money in the hands of your banker. Shortly after this case, in the 1833 King's Bench decision of Sims and Bond, Chief Justice Denman and a full court insisted that the undisclosed provider of a loan paid into a bank account could not claim the account value on the analogy of an undisclosed principal enforcing a contract via an agent. Sums which are paid to the credit of a customer of a banker, though usually called deposits, are in truth loans by the customer to the banker. And this is a well-known case in restitution theory, paying other people's debts. So we are seeing in the 1830s, in various situations, the judges are not sure what to do in different contexts. Sometimes the money is a deposit, sometimes it's a debt, and they seem to be hesitant. It's tested again in Parker and Marchant in 1842 and appealed the next year. And here, Knight Bruce is the only judge who finds for a fiduciary account quality in Foley and Hill. This is before Foley and Hill. Knight says, I'm going to have to disagree with the whole tradition of seeing the bank deposit as a pure debt. This is a case where a very complicated will hands out all the parts of the estate, including a gift of the residuary personal estate to the testator's wife, saying, I give and bequeath to my said wife all my jewels, plate, linen, china, carriages, wines, and other goods, chattels and effects whatsoever, as her own goods and chattels forever. And I do hereby constitute and appoint her, my said wife, sole executrix of my wife. Now, to compress the reasoning, there was only £116 lying around the house in cash. But there was £21,000, which in this era would have been about £500,000 in the bank. And the wife said that the list of assets I'm supposed to get includes that huge amount in the bank, and it doesn't go to the other heirs. And Knight Bruce said, yes, that is correct. He said the will was ambulatory and would apply to all the wealth applying to all those named categories. And he departed from the bank balances debt theory, partly because he said that's the way most people in commerce talk about it. They think the money in the bank is there for them at any moment, therefore they possess it in their own minds. And we have this in sale of goods and in complex title transactions. If you have a right to possession, the court will often treat that as possession. It's a mystery, it goes back to the 15th century. And the way the Romans would solve it is that when you give money to someone else to hold or assets to someone else to hold, you appoint them your agent, and they're holding the money in their hands is really your hands. It's a kind of almost a master-servant relationship or principal-agency relationship. I'm a bit embarrassed to talk about this in front of Professor Peter Watts, but we can call this commissary possession. You hold to the commission of another person. And this technique, this fiction, is a way in which we create commercial law. An enormous amount of law emerges from this. And it's a very lengthy essay by Knight Bruce where he uses this concept of holding in the hands of another to justify this enormous part of the estate going to the wife under the will. And on the appeal, Lord Lyndhurst, the Vice-Chancellor, concluded that we should allow this quotidian, common sense usage of the concept of bank deposit to feed back into the legal doctrine. And he starts to entertain the idea that in at least testamentary causes, bank money should be seen as a deposit. Now we finally get to Foley and Hill, and we get to talk about this case and conclude. Foley and Hill concerned a bank partnership that had roots in the early Industrial Revolution. It was known as the Stourbridge Old Bank, founded in 1762, and was a country bank providing payment to the local glass and iron trade in a Midlands industrial town. It survived as a banking partnership until 1851 and was taken over by the Midland Banking Company. The Midland Bank kept on gobbling up these small banks and became one of the large joint stock banks, one of the 4 largest national banks, until its takeover by HSBC in 1992. The original Stourbridge Old Bank issued not only notes and checks, but banknotes which served as good tender in the locale. And we have to remember that the mint, which had been re-established by Isaac Newton in the late 17th century, was really bad in Britain at producing sufficient official currency for the economy. So there's a lot of private banknotes circulating, which tend to be good tender just in the locale where people know the local bankers. And this is such a case. Now, this system of personal banking, local banking, was shaken up by 2 major bank crashes in the 1860s and 70s. One was over in Gurney, 1866, and the other, which I think is less well known but more important, was the City of Glasgow bank crash of 1878. And here, a major industrial bank in which most of the bourgeoisie of Glasgow had invested either directly in shares or through trustees, crashed during a downturn of the trade cycle. And some compared it to the eviction of the crofters in the Highlands, that within one summer, a big chunk of the Glasgow bourgeoisie were bankrupted to pay for the enormous debts of the bank. And this sent a kind of searing pain for the financial system. And banking practice changed. A lot of the local country banks stopped investing in the local industry, but instead amalgamated, as Stourbridge did, and began lending only against inventory and liquid debt held by the debtor. And we then get, in the late 19th century, the rise of floating charge finance. And it seems to be driven by an idea to have arm's length depersonalized banking based on actual calculation of risk. So the bankers start to say, never invest in the actual business itself, only invest in the debts that the business controls, so that you can take over the business if it goes bankrupt, pull in the debts and recover your security. So as an aside, we can learn that in the wake of the City of Glasgow Bank, all the country banks fold into the big 4 ultimately in London. And this is a very, very big story, that the insolvency rules for banks and the nature of the banking trade means that we get a concentration of banking in London that disengages from the industrial economy. But this is in the future. In the Foley period in the 1840s, Foley, their family were iron smelterers and metallurgists. And it was Richard Foley who had started the company in 1624, the family firm. And he had made a lot of money during the Civil War, basically selling munitions and weapons to both sides. The family moved its seat to Stourbridge in 1631 and then to Hertfordshire. And by 1700, the family owned hundreds of ironworks across the Midlands. They gentrified. The 4th and 5th generation were educated at Cambridge and in a Temple and went into politics, finance, and law. A Foley daughter married Robert Harley, the Prime Minister. And by the early 1700s, the Speaker of the House of Commons and 5 MPs were members of the Foley family. So it's a story of gentrification and leaving the industrial dirty money behind. The ironworks were sold on to other hands in the 1710s. And from the 6th generation, the Foleys were now concentrating on managing their financial and banking interests, enjoying 3 large landed estates, and having fun in the House of Commons and the House of Lords in politics. Edward Thomas Foley, the plaintiff in this case, was born in 1791 and educated at Brasenose College, Oxford. He became a Tory MP in 1826. He was there in the Commons voting for the Tories all the way through the Great Reform period and voted many, many times in the governments of Wellington, Grey and Peel. No parliamentary speeches are recorded. He died without heir in March 1846, which means that the litigation concluded in 1848 happened posthumously and was probably concluded by his wife. There is a certain irony that a well-connected magnate could not protect his liquid wealth from his own bankers. And it's a kind of a bleak house twist that much of his estate was taken away by his bankers and used up by Chancery by the cost of litigation. So what happened? Foley had two accounts in the bank. One, he had a joint account where he had an active partner running a residuum of the ironworks. And this account was used about 3 or 4 times over the space of a 3 or 4 year period. And he had a second account where he had the equivalent of £1 million of value today. The exact sum was £6,117.10. And I worked out that's about 0.8 million in today's money. And that was in a separate account in his sole name, receiving 3% interest. 6 years passed and he tried to claim the money and he was told, you can't even ask us for an account where the money is. And in the first skirmish, the court said that to refuse to even report what happened to the account based on limitation is going too far, because how can parties even judge where they stand in the limitation period if you don't give them the basic information? So Foley won that first procedural skirmish. But then when he came and asked for a proper account to give the principal with the interest, the defense was given that even though we can tell you that you have this money here, and we can tell you that you used your second account a few times during the 6 years, we can also tell you that since you didn't use your main account for 6 years, you can't have the money back. Knight Bruce, the judge who believed in the deposit theory, took the first hearing. And he said that, first of all, since banks can offset joint accounts and treat all the accounts in the bank as one, the operation of the side account for the industry kept alive the other account. Now, this is the doctrine that you can do set off, that if you have 2 accounts in the bank and you owe money on one account and have a balance in the other, the bank can put the 2 accounts together and level the balance. Since one account was active, both accounts were active. That was rejected. And the second argument that the judge offered was, banking is a relationship that is intrinsically accountable. That since you've got someone managing your money, but they have to pay you on demand, we shouldn't really be applying a debt model for limitation to this type of account. It went on appeal to Lord Lyndhurst, and much evidence was given that Foley had actually written in quite a few times to the bank asking, where's my money? Lord Lyndhurst cited all of the past law that we discussed in the testator cases and the debt cases, and he gave the following doctrine. It is quite clear that a banker is not to be considered a trustee for his customer in the legal sense of the term. Money advanced by a customer to a banker is a loan and constitutes a debt. And we will apply the same limitation period to this debt in a court of equity by analogy as we would in a court of law. Since there was no fraud involved in holding the money back, but there was simply the passage of time, and since Foley had failed to pursue the evidence of any breach in the relationship and only had a few stray letters that weren't strong enough to form a proper report on the bank, the judge concluded that the statute of limitations is a sufficient defense. Another argument was given that all of this accounting between different accounts and looking for where the letters were is such a complex accounting process that we get dragged into a court of equity that must put the parties onto inquisition, which revives their claim. That there's a kind of a second round of procedural argument that the need to unpick a complex account brings this within a fiduciary framework. This is also rejected. There's a third appeal goes to the House of Lords 4 years later. And in this period of the law, it was quite difficult to constitute a judicial committee. You needed a bunch of retired Lord Chancellors who were available to form a court. So they put Lord Lyndhurst into the court to decide an appeal against his own judgment, which did happen. And even though he was the senior judge, because they were appealing his judgment, he was told to go last. And a lot of argument is given from authority and from the testator cases that the court should recognize, because of the deposit nature, the bailment nature of the bank deposit, that we should therefore extend the limitation period, and the court rejects it. Now, I'm conscious of time, so I'm not going to go into the language of the courts, but I will give Lord Cottenham's statement, which I think is, I have it here. I didn't give you this. Okay, let me read it out to you and then we'll conclude. This is the ratio. Money when paid into a bank ceases altogether to be the money of the principal. It is the money of the banker who is bound to return an equivalent by paying a similar sum to that deposited with him when he has asked for it. The money paid to the bankers is money known by the principal to be placed there for the purpose of being under the control of the banker. It is then the banker's money. He is known to deal with it as his own. He makes what profit of it he can, which profit he retains to himself, paying back only the principal according to the custom of bankers. The money placed in the custody of the banker is, to all intents and purposes, the money of the banker to do with as he pleases. He is guilty of no breach of trust in employing it. He is not answerable to the principal if he puts it into jeopardy. If he engages in hazardous speculation, he is not bound to keep it or deal with it as the property of his principal. But he is, of course, answerable for the amount because he has contracted, having received that money, to repay to the principal when demanded the sum equivalent to be paid into his hands. Now, what follows from this? 1848, we haven't yet had the migration of banks into a limited liability world that followed the City of Glasgow amalgamations. So we still are using this partnership theory of personal liability, but we're in a period where the bankers are no longer personally known to and pledged to their customers. It's a kind of a cusp period. And I think Foley and Hill is extremely interesting to show how the differences amongst the judges, they're hesitating as they produce doctrine to allow this depersonalization of credit. That seems to me to be one lesson. Another lesson is that the judges are pretty well aware of how banking practice works. Typically, 20% of bank capital is kept in the bank to pay out depositors, 60% is lent out to generate money for the bank, and 20% is invested by the bank as proprietary capital, generally in long-term government gilts. And the bankers in their discussions seem to be well aware that this form of fractional reserve banking with a band of stable capital is the way in which the banking is working. What's quite interesting is that the problem of a debt without a term remains unresolved in the law until 1980 in English law. When finally in the Limitation Act, Section 6 says, this act shall not bar the right of action on a contract of loan to which the section applies. For example, if the contract does not provide for repayment of the debt on or before a fixed or determinable date, and does not effectively make the obligation to repay of the debt conditional on the demand for repayment, in these conditions, we don't apply the limitation period. In other words, Foley and Hill is no longer the law, that the 1980 Act overrules the ratio of Foley and Hill. It's quite interesting. I don't know whether that solves the problem by brute statutory force. And I won't name names of my colleagues. You might be able to guess who I'm talking about. But I have a friend in Oxford. We go out for pizza and he always forgets his wallet. And he says, Josh, can I have 10 pounds? Can I touch you up for 10 pounds? And I say, again? What about the last time? And if I give a loan to my friend of 10 quid because he can't afford to remember to bring his money for pizza, is it a debt or a gift? It'd be quite rude for me to actually write to my friend and say, pay me the 30 pounds of pizza money from the last 5 years. But there's an interesting question. How do we understand a debt without a term? Now you could say, well, there's an extra term that when I actually write to you and say, now pay me back, then we put an end on the term. But does that conflict with the limitation period problem? I haven't got the tools to work out a doctrinal question. What does it mean to have an obligation with no terminus? Interesting problem. The bankers were overjoyed by Foley and Hill, and I read into banking literatures, their magazines, and there's hundreds of pages of commentary on how great this case is, resolving all doubts that bankers are allowed to use their depositors' money to generate more and more credit. And one genius banker, known as Henry Dunning MacLeod, in his Theory and Practice of Banking, 1855, many, many editions to follow, says, "Nothing can be more unfortunate or misleading than the expression which is so frequently used that banking is only the economy of capital and that the business of a banker is to borrow money from one set of persons and to lend it to another set. Bankers no doubt do collect sums from a vast number of persons, but the peculiar essence of their business is not to lend that money to other persons, but on the basis of this bullion to create a vast superstructure of credit, to multiply their promises to pay many times, these credits being payable on demand and performing all the functions of an equal amount of cash. Thus, banking is not an economy of capital, but an exponential increase of capital. The business of banking is not to lend money, but to create credit. And by means of the clearinghouse, these credits are now transferred from one bank to another, just as easily as a credit is transferred from one account to another in the same bank by means of a check. And all these credits are, in the ordinary language and practice of commerce, exactly equal to so much cash or currency. This is Ludwig von Mises' nightmare. Unbridled credit creation with no visible means of support if there's a run. And my discovery in writing about this stream of old authority is to raise the question that von Mises proposes. Should we take seriously an alternative tradition which sees money in banks from certain depositors as real deposits? We learn from the story that small shifts in private law doctrine can contribute large effects in the public and economic sphere. We have some intriguing counterfactuals. Could a more rigorous private law have reshaped credit production and prevented this disalignment of British banking from British industry and the collapse over time of the British industrial sector? Could heightened duties of care and accountability for bankers sounding in private law curbed the irrational exuberance and dangerous credit bubbles of more recent times? The judges in Foley dimly perceived that their pure debt theory would free up the banking sector to create credit without restriction. They could not foresee where it would end. As we peer into the murk left by Silicon Valley Bank and Credit Suisse, the problems of fractional reserve banking and systemic fragility have hardly vanished from the scene. And it might be that this dose of legal history can help us to see that through the murk. Thank you very much. Nuncio.
Oh, can I be heard? Hello?
Yes.
I'm done now.
Good, thank you. Thank you, Professor. Look, I would commence my vote of thanks by saying pizza is always a good reason to lend money, particularly if you're participating in it. Look, thank you for that. I'm not sure that this has made any easier the answer to the question which I'm increasingly asked these days, and that is, what is money? But it's pleasing to see that it's not actually a new question, or that its difficulties are not new. They're just exacerbated by the emergence of cryptocurrency and the like. But it's interesting to see that it's always been a difficult question to answer. Look, this discussion has been extremely timely, particularly given where we're at and where, God forbid, we may go. In terms of discussing the historical underpinnings of modern banking and the layers of complexity within it, the role of bank debt, especially overdrafts, in post-industrial revolution Britain and thereby Australia, and the role of bank accounts in the growth of banking itself. As I said to a class I was lecturing just recently while talking about the recent events, banks are basically insolvent, with the only thing keeping the doors open being the element of confidence. And that element of confidence comes from a combination of things, not just the government support, the implicit government support, but as you say, the work of lawyers, the work of the many people that surround and underpin the banking system that gives mums and dads and the rest of us the confidence to give banks our money, hoping that when we ask for it back, it'll be there. So anyway, timely and very relevant. Professor, thank you very much. I hope it's not too long before we see you again on our shores. It was a pleasure and a delight to have you with us. And thank you again for your excellent presentation.
Thank you. Before we go, can I just respond very quickly to 2 comments and add a couple more
Yes.
business school type comments?
Yeah.
I'm going to ask you a question. I'm going to play a historical guessing game. How many banks went bankrupt in Britain in the 1930s crash?
I couldn't
Pick a
begin to
number.
guess. Several dozen?
In America, it was hundreds.
Yeah.
In Britain, it was 0.
Oh, they're right.
Why was that so? And the answer might be that the banks were basically packaging up bonds to export to build railways in South America. They were not involved in their own economy. Right. You could have the complete wasteland and 40% unemployment. It didn't touch the London banks because they were not investing in any type of capital at risk in their own economy. And I think we need to study Pistor's style, the law that led the British banking sector to turn its back on its own country. So when we're told we need the City of London to keep the country afloat, there's a counter story to tell, which is the City of London's prominence in international banking suits part of the country, but ignores much of the country. And this is something we struggle with in the politics of Britain. Australia, New Zealand, America, all very, very different stories. And the other point is, there's a differential in bank recovery of capital lent to industry in different economies. And I'll give you another raw figure. American banks recover 40 to 50% of their loans to companies that become insolvent. And the figure in Britain, with various floating charge and other forms of security, is 90% recovery. So one argument would be that the place we are in Britain, at least, and I'm sure it's very different in other jurisdictions, is that the legal system has step by step favored a particular stratum of the banking sector and maybe pushed the risk too far towards other parts of the economy and other actors. And I suppose this is where this paper will eventually go and try to explore these legal issues. So can I thank everybody for attending and for hearing out this dense historical argument. And please do send me any messages or thoughts or ideas to help me develop this project. And I'm very, very grateful indeed to engage with the BFSLA. And thank you very much for this afternoon.
Thank you.